Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan, and we're continuing our video series about family law issues and personal protection orders today, so please subscribe to our channel. A lot of times, well, let me start out with a little bit of history, okay? The PPO statute, the statute that allowed people to get personal protection orders, had its roots in the battered wife situation, where somebody literally needed a court order to keep a spouse away from them. There was a real good intention when the statute was drafted, and it really had a place designed to protect would-be victims. The problem with the statute, it has been abused. It has been abused where people will come in, claim they need the PPO. Why? Not because they need the protection, but because if they get the protection to keep him away from her, then you know what'll happen? He won't be able to see his kid either. So a lot of times we'll get unfounded PPOs where there's wild allegations. The court has no choice but an abundance of caution to enter that PPO, and now it interferes with parenting time. It's entirely possible that your ex could get a PPO and all of a sudden you can't see your kids. Now the court is wise to it. If the court feels that somebody did that just to jockey for a better custody position, the court will take action. It will backfire. The court will see that there's nothing more than a deliberate effort to interfere with the other's parenting time. That'll be held against the person in the ultimate custody determination. But you've really got to be mindful of the fact that in reality, until the court figures out that the whole thing is a ruse, you could get stuck not seeing your kids because of this bogus PPO. And even if you have your attorney file a motion to set aside that PPO or file timely objections to address that PPO, it could be weeks before the court renders a decision on that hearing after it calls witnesses and hears all this. And so all that time, are you seeing your kid? If you are, it's under very, very serious restrictions. So therefore, if you think that you are vulnerable to this, if you think that this is something your soon-to-be ex might do, then you got to take yourself out of the situation. You've got to make sure that nothing escalates. If you feel that the police might be called, PPOs and all that stuff may start flying, you better make sure that you have pulled yourself out of that equation so that they won't be able to do that to you. And even with every effort that you make, they might do it to you anyway. They might find a way to draft that PPO, and the only thing you've got going for you is the courts know that people do this, and your attorneys are going to know how to file the appropriate motions to set it aside. And they can ask for sanctions if the court determines that it was frivolous, for example. But I got to tell you, a lot of times we find that people will say it's frivolous, and then we'll learn it's frivolous maybe, but they kind of also did something that put the person in fear. They perhaps said something that they shouldn't have said. I had a client once who told somebody, you do that to me, I'm going to put 2 right in your forehead. And it was just a slang expression. He didn't mean he's going to shoot 2 bullets in the person, but it was enough. It was enough for the court to say, you know what? I'm keeping you away from you. I'm entering the PPO. Because if it's even in your radar to say such a thing, I got to protect the other party. And it causes an impact. So you always got to be careful about that kind of thing. Now, if you have any questions about your case, reach out. We'll be glad to help you out.